The Minister of Justice and Correctional Services is briefing the media on the proposed provisions of the Traditional Courts Bill. The bill has been approved by Cabinet for public consultation and will soon be tabled in Parliament.
Promoting social cohesion. The payment of compensation may, however, not exceed the value of damage giving rise to the dispute or the amount determined by the Minister of Justice by notice in the Gazette from time to time, whichever is the lesser. Any community service ordered must be for the good of the community and not for the benefit of any member of the court or a traditional leader. Provision is made for the review of procedural shortcomings in the High Court, for instance, if the court was not properly constituted or the parties were not allowed to be represented by persons of their choice. The High Court can confirm, alter, set aside, or correct the order made by a traditional court, set aside and correct the proceedings of the traditional courts, make the order that the traditional court ought to have made, or remit the case to the traditional court to deal with in the matter ordered by the High Court. These reviews will contribute to precedents and enhance jurisprudence in matters of this nature. We believe that the enactment of this bill will benefit millions of people who continue to lead the traditional African way of life, and equally these courts enhance access to justice for all those who choose to use the courts as an alternative vehicle to resolve disputes. Deputy Minister Bapela and officials will be able to comment on the technical aspects of the bill which may be raised in relation to the bill. Maybe just to raise the other point, the bill was approved by Cabinet, as you know, in December last year. It will then be introduced to Parliament. There will then be an extensive public participation process in Parliament. So this is effectively where we hand the bill over to Parliament as the executive for processing. Thank you very much.
Thank you very much, Deputy Minister. I omitted to mention the name of the Director General from COPTA, who is Dr. Charles Kumaila. I apologize for that. It was not my intention to exclude you from this plan. Thank you. Mzee, do we have journalists in Cape Town?
Yes, we do.
How many do we have there?
No.
Okay. In 2017, we cannot count. We will start here in Pretoria. The rules of engagement are very simple. You introduce yourself and the media house that you represent and ask that question, not a comment. And then we'll have one round here and then we're going to Cape Town. Whose hand is up? Only I'm noting you. Any other hands? Maybe JJ, you were eloquent and articulate enough in one question only. Over to you.
Maybe they're not traditional.
Thank you very much. Thank you. Colin Gambi from ENCA. I suppose I'm much more interested in the technicalities. Regarding, for example, the use of lawyers in these traditional courts, will people be allowed to use lawyers to represent themselves? And also regarding punishments, previously there were complaints that the punishments meted out at these courts are too excessive. People, for example, will be stripped of their land or property. In other instances, there will be cases of forced labor. So how far does this go in as far as that is concerned? And also, just lastly, regarding the judgments, my understanding is that the previous bills have said that you cannot appeal at these very same traditional courts. Will people now be allowed to appeal cases at the same courts, or should they go to your conventional courts to try and seek an appeal? I'll leave it there for now. Thank you.
Thanks, Dolly. I'm sure you've inspired some. Can we get any more hands in Pretoria? In the absence of any, before the follow-up.
Yes, my name is Mila Magnuson from SABC Radio News. I just want clarity to say, although legal representation is excluded, the system allows assistance of women and other vulnerable members of society. Can you just explain to me exactly what that assistance entails? Is it someone from the community that will assist them if they are not allowed to bring outside legal representation?
Follow-up, Tony?
Yes, thank you. Quickly, if I may. I may have missed it in the statement, but is the bill clear that this particular, that this is optional? If you want your case to be heard in a traditional courts, in a traditional court, is it optional or is it not? Because if not, then perhaps there needs to be an explanation there. The assumption would be there ought to be one law for one nation, and the supreme law of the country is the Constitution. Thank you.
Thank you, Tony. In the absence of other questions, do you have anything to final?
Can I do something? I think. Yeah, I'll just start. Tolly, we must give you a copy of the statement to read. But just firstly on the issue of legal representation, the bill does not provide for legal representation as other versions of the bill had also done. And that was, but previous versions of the bill, the courts had criminal jurisdiction. Now they don't. In customary law, there isn't really any distinction between civil and criminal, and they're effectively dispute resolution courts. Reflecting on the outcome of the stakeholder engagement, the general view would be that because the traditional justice system is essentially consensual and voluntary in nature, legal representation is undesirable. The traditional justice system is geared towards achieving conciliation between the parties in a non-adversarial manner, unlike the courts. It was argued, therefore, that there was no need for legal representation and that a party in a traditional court should be able to be represented by any person of his or her choice, including a family member, whether male or female, a friend or a counsellor. The discussions pointed sharply to the fact that these courts operate in a manner which is entirely different to that applicable in other courts, and the introduction of legal practitioners will take away the benefits of a speedy, cheap and accessible system. And so the general view was that legal representation is not suited for the traditional justice system. And the bill therefore provides that no party to any proceedings before a court may be represented by a legal practitioner acting in that capacity. So you can represent someone but not acting as a lawyer. The issue, if you look at small claims courts, they don't have lawyers. They don't have any legal representation. The moment you bring them in, what is meant to be a sort of quick, expeditious way of resolving a dispute would get dragged out with all kinds of technicalities. On the issue of appeals, the issue is that there are not. Previously under the colonial system, in terms of your layers of courts, you had the traditional courts sitting under the magistrates' courts. So the magistrates effectively, in the colonial system, particularly an apartheid system, were there to make sure that the traditional leaders behaved. That linkage has been removed. So if there's any appeal, one of the issues that the bill does is recognizing that in different customary systems in South Africa, one size does not necessarily fit all. People in different communities do things differently. They need to be given the space to do that according to their customs and traditions. So the provision largely is that if somebody is unhappy with the decision of a traditional court, they can make use of internal. Many customary systems do have internal systems of appeal, so they could make use of that. However, where the linkage with the High Court is that any matter obviously can be taken on review. Review is linked up to procedural aspects. So you'd be aggrieved about the process followed, the manner in which the court was constituted, those kinds of things, and that you would take on review to the High Court. The penalties issue was dealt with in the statement, but just to repeat it, it's basically that there isn't it's in the statement, so it largely is. In terms of the bill, an order may be expressed in monetary terms. I mean, it's basically a compensation, so it's not a fine. It's a compensation to the person who's brought the case in the court. And that may be expressed in monetary terms or otherwise, including livestock for the payment of damages suffered. But then there is a condition that the order for damages may not exceed the value of the damage in question, or the Minister of Justice will be able by regulation to cap an amount from time to time in the Government Gazette. Other orders include an order prohibiting the conduct complained of, an order that an unconditional apology be made, an order requiring a party to keep the peace, and all the orders that are suggested in the bill are of a restorative justice nature. The bill does permit, as I'd raised, an order of community service on condition that it is for the benefit of the community as a whole, not a specific individual. The last question on whether it's compulsory, as I'd raised in the statement, and it is there, that these are of a voluntary nature.
Maybe just to add on that one, yes, any person can opt out if they do not want to participate in the traditional court system or arrangement. However, that opt-out must be right at the beginning of the proceedings, where you indicate and declare that I wouldn't want to go through this particular process, not in the middle when the matter has already been allowed to proceed. Maybe because you could see that it's not going your way, and then in the middle of nowhere you say, I'm opting out now. But you have to do it right at the beginning. And I think that's what the bill has a system that then begins to say, it's a voluntarily, and you've got the right to opt. And then those who may have brought the matter, they might then have to seek justice from other processes of the law that are there in the land, if they want to pursue the matter, because the person that they are accused will have wanted to opt out. And then we can go to the small claims court, we can go to the other magistrate courts and so forth. And the matters that the traditional court will deal, we have in the bill also clarified that criminal and civil matters will not be entertained in any of the traditional courts, because those are automatically of criminal nature, rape and murder and assault to grievously bodily harm and so forth, or any of the civil matters will not be heard in the traditional court. So I think the bill has really clarified quite a number of those in relation to the previous bill.
Maybe just to add on that point of opting out, you can't just ignore. So if you get called to the court, you can't just ignore it.
Yeah.
But all you've got to do is you've got to indicate to the clerk of the traditional court that you don't want the court to hear the case. You don't have to give reasons. There was quite a long debate around that, and that if you required people to give reasons, it may cause more disunity in the community. The clerk is meant to check whether any other traditional forum could deal with the matter, but that's basically it. But you can't ignore, but all you've got to do is say, no, I don't want my matter heard by this court.
Thank you very much, Deputy Ministers. JB?
Thank you, on a lighter note, don't assume that everyone knows so. We must also introduce one. But one thing that I wanted to add on this matter is the whole issue of appeals. Appeals, in the manner we know it, in the contract court, is a very detailed process that would require that there must be evidence of the records. The appeal courts work on the basis of evidence that was submitted. Traditional courts would not use, would not keep deter courts because they're basically aimed at finding a solution. They just want a simplified statement of case and negotiations on how they can resolve the session. So the bill introduces not an appeal but an escalation. That's what it basically happens in the traditional court setting. Matters get escalated to the next level or to other forums, etc. And that's what the bill actually. This bill does not change custom record. It basically provides a mechanism for the Board of Customer Law to basically be implemented, enhanced in a manner that contributes or supports restorative justice. The last point obviously is that customary law by its own nature is a representative. So in disputes, even before it goes to courts and family members, matters are reported to uncles. Umaluba are the ones who take matters with the other parents to resolve the matters, etc. So when someone receives an invite, someone to go to court, it's inherent. They will be accompanied by someone in their family to provide whatever assistance they require, especially if they are children and women. It's the nature of the system itself. So the representation is only part of the customer law system itself. And I think through this process, it's those things that are here to promote social cohesion that the bill will promote. Thanks.
Thanks very much, JB. DJ, do you want? All right. Mzi, do we have?
Yes, I'm told.
Do we have questions?
Yes, I'm told. We have a question from Cape Town, Marianne.
Thank you. Good afternoon. In the absence of either the statement or the draft bill, please bear with me. They've not been made available in Cape Town. My question centers around in terms of what section of the Constitution are these courts established. Previous traditional court bill was silent on this. Are these courts in line with section 166 of the Constitution, like for example the Small Claims Court? Are you concerned all aspects of potential unconstitutional?
Now, that is the media briefing on the traditional court bill, which is currently underway. Justice and Correctional Service Deputy Minister John Jeffrey briefing the media on that traditional courts bill. Deputy Minister has said that the bill is fundamentally different from the previous versions.